guys, it's a pleasure to see you today in the second day of the Digital Asset Investment Conference. We are going to have an array of amazing speeches today as well. We're having two panels. One is dedicated to legal aspects of digital assets offering and starts less than in 10 minutes. We'll be speaking about how you should choose the right jurisdiction, about the regulation and the future of decentralized finance, about the cost of offering digital securities, and many, many other things that you should know before doing anything in the space of digital assets and digital securities. Okay, our panel should start right now, just in a minute or two. Please, I am asking all the participants of the panel to join in and write in the backstage chat if you're here, because we need you to join. Administrators, please let the participants in.
I think that we could start with the part that is the most controversial, let's say, between regulators from Europe and the United States. We could start with discussing when a utility token is actually not really a utility, but rather a security. Hi, Steve.
Hello.
Great to have you.
Meet you again. Glad that you could join us.
Pleasure to meet all of you.
Yeah, Boris has actually made the introduction for all of us. So I suggest that we skip the introductory part and we moved already to the first question of the agenda that I sent you yesterday. And I started with the question about, let's say, in the legal terms, qualification of a security, because tokenized security is still a security or a financial instrument in most of the jurisdictions. And we started discussing the difference, how regulators see security in the US and, let's say, in the rest of the world, because we have seen, especially in the Russian-speaking audience, the most famous case was the Telegram story, when the so-called utility token turned out to be not really a utility. Zach, could you elaborate on that a little bit more?
Sure, thank you. So I think you said it very well when you just said that a tokenized security is still a security. There was a time a few years ago when folks in the US thought that if they just recorded ownership of these contracts on a distributed ledger, they would magically evade 80 years worth of securities laws, and not so much. The SEC, so the federal regulator, as well as state regulators in the US, determine whether something is a security based on the economic impact of the product, of the instrument, not based on just how ownership of it is recorded. So basically, the same tests, long-standing tests from decades ago that are used in the US to determine whether a traditional product, traditional instrument or contract or whatever is a security, the same thing applies to instruments recorded on the blockchain. And so you're right when you talk about the Telegram case and such. Lots of people have tried to paint their securities as utility tokens, which is to say non-security tokens. And to be clear, under US jurisdiction, utility tokens do exist. Not all tokens are security tokens. Some people are running scared and saying every token in town is a security, and it's not as bad as that. But it is also not enough just to say, I'm issuing this token and it can be used either now or theoretically for something. And so because of that one bit of utility, it is automatically not a security. Rather, we go back to, are people investing in this because they expect to make a profit because of someone else's activities, either the issuer or some third party? If so, then it's a security. So even if you are issuing something that you say, you can use this to use our system once we build it, and the system's not built yet, so we're going to use the money to build it, and it's going to become more valuable once the system's live. Well, guess what? People are buying and building these not because they're going to use your system a million times, but because they're going to sell these tokens when they appreciate. That means they're securities. So there are a lot of opinions from the SEC over in the US expressing what is and is not a security. So there is much less uncertainty now than there had been. Occasionally there are proposals to change laws, but it's a pretty clear line now. Of course, there's always a gray area, but it's not as bad, not as mysterious as it was a few years ago.
Okay, great comment. I just have to point out once again that it is different from how regulators see it, let's say in Europe, because still tokens where you can purchase with a token, let's say a tree, a plant of marijuana, a bottle of wine, they're still considered to be utility tokens here. But once you start selling them to the US investors, you should be really extremely careful, I guess. Natalya, Steve, what do you think? What would be your practical advices to those who, let's say, want to wrap whatever they're offering to investors or consumers as utility tokens?
Well, maybe I go first. First of all, sorry that I missed the beginning here with the technology not being kind to me this morning. I just want to add one thing before starting, because in the banners that were promoting the event, I was described as the author of the Maltese laws. That is not accurate. I'm the author of the National Blockchain Strategy. And then, yes, I participated as an advisor in the legislative process, but I am not the author of the laws. And I should say I'm not a lawyer either. So I'm honored to be on this panel with so many lawyers. And I know I have to be careful because anything I say can be used against me.
Not this time, don't worry.
Okay, so I relax. Well, thank you. So I can give you like the Maltese perspective. Malta was the first country to actually enact laws in this sector, and they are extremely clear. And we have a so-called financial instruments test, whereby by exclusion, if it's not one thing or the other, excuse me, eventually it is a virtual financial asset, which would be what we know as a token. If it is anything else, either it is just a virtual token, which is what Zachary referred to before. It's like a ticket for using something, like a coupon, but it's not subject to any kind of trade or speculation. Anything else would qualify as a financial instrument, and thereby be completely subject to MiFID II and the existing European laws in the matter. So the way we have done this in Malta, I think, is an example of clarity, because we did not in any way subvert the existing laws in the matter, and just recognize that there are some fundamental structural differences by which virtual financial asset can be distinguished and thereby be subject to these other laws that we have in Malta. One of which I want to highlight is the institution of a new kind of regulator. It's called the Malta Digital Innovation Authority, which takes care of looking into the let's say the technology aspect of these instruments. The big difference of virtual financial assets with conventional securities basically is that they are built on top of these crypto technologies, and in particular, many of them, especially those that are tokens or borderline between tokens and securities, they have the action of smart contracts implementing the promises that the seller does to the market. Those smart contracts are obviously a huge element of risk. They can fail. They are software. They have all the problems of software, and therefore the idea was that we needed to give some guarantees to the consumers that these software artifacts were actually delivering what was being promised. And the remit of this Malta Digital Innovation Authority is to provide those aspects. So I would say, if you are launching a token offering a virtual financial assets, in Malta, you would be providing quite some degree of peace of mind to the consumer, even for the crypto aspects of the instrument that is being proposed.
Okay, I see. I think that we are already moving more or less to this summary of for security, let's say conducting security token offerings in some of the countries. But before we move to that, I just wanted to give the floor to Natalya. What do you think about wrapping up whatever projects offer as utility tokens?
Yeah, hi everyone. Is my connection good? Yeah, so you know that just a few words about myself. I was before the previous year, I was a partner of Big Four of Deloitte and also was dealing with some blockchain services and solutions. And I want to say that it was one of the most complicated scenes because you know, here in Ukraine, we do not still at that moment on the territory of Ukraine, there is no delimitation of tokens at the legislation level. So we have only the the basic law connected with digital assets, and the difference between security and utility is highly ununderstandable. So for most clients, I would like to determine their position from the clients. We are dealing with some investment projects, and it is very difficult to clarify the difference between security and utility. Token. It's the most important for the investment project. Such a token takes the high rank, and the implementation of the investment project becomes more relevant. So you know that so what we have done. So we before tried to use the Howey test developed in the United States and the possibility to determine whether the transaction is related to the upcoming of already completed investments, or if it is an acceptable zone. And nowadays, I hope that we're gonna take their example of some Malta or some Switzerland legislation in order to implement it in Ukraine. So I would like to ask you, so how you solve this problem in your country?
Okay. Good. Maybe I could wrap it up because Switzerland is not part of the EU. It has bilateral agreements with EU, but it is still part of the continental system, legal system. Let's say countries took it more or less all from the Roman Empire and Germany, which implemented what was invented in the Roman Empire. So what Switzerland does, definitely they do see most of the utility tokens similar as in Malta, some sort of coupons which you use to purchase something, and it still works in a lot of projects. And I think there is some sort of consensus about how you qualify utility tokens in Europe, but it is still really not really fixed. It might be regulated in the future, and it will be, I guess, also by MiCA, the proposed EU legislation for the whole European Union. But till now, we could have utility tokens, which are not qualified as security. But as we have seen in Telegram case, and also in other cases, some of the utility tokens which were issued in Switzerland or European countries, if they're offered to the US investors, they really can be qualified as security, and that's where projects should be really, really careful. Because some of them still think utility token is unregulated, we can offer it everywhere without running a risk to be banned by the regulator. This is not true. They should be really careful about the market, the target audience where they offer it. That is, let's say, to wrap it up, my practical advice. Well, not really an advice, sorry. We're in a panel, we're not really allowed to give any sort of legal advice, but that is just a practical solution, I would say. Well, let's move to the regulation. I will start maybe with Switzerland and Liechtenstein. On this panel, we really try to focus mainly only on security token offerings, because to try to cover in one panel all the crypto regulation with FUD, the security token offerings and the stable coins will be really too much in my opinion. So let's focus on security token offerings. In Europe, just as Steve mentioned, since Liechtenstein is a part of the European Economic Area, most of the security tokens fall under MiFID. There is nothing extremely new about it. Tokenized security is still a security. And to conduct a public offering, you can either have private placement, then you fall under exemptions of the prospectus directive. Or if you do a public offering, then you also have some sort of exemptions, like accredited investors, if you offer it in the amount starting from 100k euro, etc. There is a list of exemptions from the prospectus directive. Then, if you issue a prospectus, of course, you have the advantage of so-called passporting, which is the opportunity within the European Union. When you get your prospectus registered with one of the European countries, you are allowed to notify regulators in other countries, and then you can offer your security tokens within the entire European Union. That is the advantage of the single market for financial services. That is to wrap it up for European Union, let's say. But then, for now, there is a fragmented regulation on a national level, because some of the countries don't have any regulations. Some of the countries have clarifications by regulators or by governments, and some of the countries have already national laws. And that is the example of Liechtenstein, and then we could move to Malta and maybe mention some other countries. So Liechtenstein has been working for 3 years on the so-called Blockchain Act, Trustworthy Technology Act, where they've introduced the definition of token as token container model. Let's say it is just a digital wrap for whatever you put inside. If you put inside a security, then it is a security. There are a lot of civil law regulations within this act, and actually doesn't really touch everything related to MiFID. So that is the national regulation. What is the most important thing that they talk about? So-called dematerialized securities, uncertificated securities, and they say that security token, most likely it is uncertificated security, and the transfer of those securities can be done on the blockchain. This is the innovation both in Liechtenstein and in Switzerland, because Switzerland has been also really, really progressive on that. And I think that security tokens really fit into the already existing financial markets, both in Switzerland. It is well developed and well known in the world. So what they did, there've been, I don't know how many articles and discussions of what security token is, and the conclusion, the latest was, it is an uncertificated security most likely, and the transfer of it previously, or it still is in a Swiss law, that the transfer of uncertificated security should be done in normal way, using handwritten signature. And you wouldn't do it on with tokenized security, right? So what they did, and what is introduced in they call it also the Swiss Blockchain Act, but it is actually amendments of several laws, including bankruptcy law. The major innovation is that security token is uncertificated security, and the transfer can be done on the blockchain. So yes, I think this will bring a lot already to the existing markets, and I would be happy to hear about the current, let's say, regulations or interpretations. In Malta, Steve already mentioned that, but maybe you could add something to this. Zach, Natalya, what would you say about regulations in your countries for security tokens?
Well, as I mentioned in Malta, the situation I think is very simple, because if you are in the security space, you are under MiFID II. It's only the embodiment that changes. It's not a piece of paper, so to say, but it's a cryptographic signature on a blockchain that holds the rights. So from that perspective, I see that the evolution of this field in Europe will quite quickly converge to a uniform interpretation of how to regulate this. However, I'd like to reflect on, because I'm always like the visionary, reflect on the fact that in all these efforts, in all countries, even if we are like focusing on security token offering, the legislator and the regulator is not quite understanding what this technology is bringing about. What do I mean? The regulation of the primary markets is still exercised when going over to the crypto security space, is still exercised according to conventional and traditional regulatory constructs. But we are going to face, no matter how we are evolving these laws now, a matter of virus, the strength of the law, which in the crypto space, because of its nature, cannot be actually exercised and applied. So even the securities market should start, the securities regulation should start thinking about how to exploit this technology. We've had lawyers since the early 2000s with Lawrence Lessig and his ideas of code is law, which with the smart contracts, all of a sudden in 2016 with Ethereum became very, very tangible. I think that concept needs to be taken further and actually turned around. Not code is law, but law is code, meaning that the regulations and the laws should be encoded on chain, and thereby all these issues of interpretation and is it this or is it that are resolved at the source. So, of course, that needs a lot of legislative development, new concepts, and it also needs the development of, let's say, GovTech or RegTech, to the extent that the underlying infrastructure representing the obligations to law is encoded on chain. And I have some more things to add to this, but I will reserve that to later.
Great, thank you. Natalya, Zach?
So for me, the main question just was that I was asked by many clients and many partners that was, are there any possibility somewhere worldwide, like in Liechtenstein and somewhere else, well, to deal with securities? Like many people know that some jurisdictions, their securities transactions, they involve complex procedures, but like some signing securities, transferring them to public business registers. Are there any possibility? So I wonder if there are any possibility, like in Liechtenstein or somewhere else, well, to simplify this process, like that we do have some small requirements. We could transfer securities with no regulations and just to inform business register somewhere, well, at the end of the year. So if someone could answer me this question, I would really appreciate it.
Yeah, we will talk about custody of security tokens a little bit later on. I will just give the word to Zach about, let's say, overall regulation for security token offerings, and then we move to practical issues of STOs.
Well, thank you. So when it comes to issuance, it's very much in line with what you were describing, Yanina, about you can do a full-on public issuance of these security tokens. In the US, that falls under the Securities Act. And so you enter a registration statement with the SEC, have disclosures galore. So it's a costly thing, but the trade-off is then sky's the limit. Raise as much money as you want, raise money from anyone you'd like. People can sell security shortly after they buy them. Life is easy. Or you can save yourself a lot of money by falling within one of the exemptions from the SEC, from the Securities Act. But you do that by accepting some kind of restriction on your raise. Either I'm not going to raise more than this many dollars, or I will only take money from rich people, accredited investors, or I will only take money from people outside the United States, or I won't advertise, or I won't do this or that. Various things, you accept restrictions and thereby buy yourself an exemption from the Securities Act. So a lot of what we do is help issuers decide which exemption they want to use. And then the security token offering can work. They just have to decide what restrictions they're going to accept. You mentioned, Yanina, about needing a signature for transfer and such. Fortunately, we've not had that kind of issue, some kind of traditional must be signed in paper question. There are restrictions on transfers, but it's not the means through which they're transferred, but rather who is allowed to transfer them and when and with what disclosures. So that is, if you want to sell a security, as an issuer, you have to either follow the Securities Act or follow an exemption. If you're not an issuer and you're not a broker or a dealer, then you can sell things. But there's a question of whether you're acting as a broker or a dealer. A broker or, yes, a dealer on this, and a distributor on this. And that is often determined by just how long you held the security. So there are restrictions in the US on, okay, yes, you can issue these security tokens, but then you have to force people to hold on to them for a year. Plus, we have restrictions on where these can be traded. I mean, like most other countries, we have rules for launching exchanges, and there are limited exchanges in the US that permit listing of security tokens. So that in practice makes it hard to trade these things immediately. The issuance is not really that bad if you're willing to accept one restriction or another, but then you have to convince people that they're going to like what they get given those restrictions, and you have to have some way from the technical standpoint to enforce those restrictions so you actually can fall within the exemptions.
Absolutely, absolutely. I think that exemptions that you talked about, I just wanted also to discuss a couple of examples maybe that you have seen. Are there many Reg A plus security token offerings that you have seen till now for retail investors? Because I have seen just one.
So it's a very good question. And so when we look in the US, short of full-on public issuances, we primarily talk about Reg A, Reg D, Reg S, and crowdfunding. Mm-hmm. So Reg D is basically limiting yourself to accredited investors. There is Rule 504 under that when it's under 5 million, but we haven't seen a lot of people use that because of the residual exposure to state regulations that makes it a pain to make those issuances. So usually if you use 506, people limit themselves to accredited investors, which now, given the anonymity of purchase and such, mean you have to have some kind of vetting of the investors at onboarding. So you might go through a platform that checks the financial situation of the investors, so you make sure as an issuer they're only selling to accredited. So that's Reg D, and if you can get that vetting, then it works. Regulation S is where you say we are selling outside the United States, and then as long as you check ISP addresses and get people's promise they're not going to resell back to the US and such, that pretty much works. You have to follow the regulations in the jurisdictions where the investors live, but often those are not as onerous as the US one. So a lot of companies do this. Say we're going to issue these securities, but only outside the United States. Crowdfunding is great, but it by definition is for small amounts, small total amount and small amount per investor. So we see that for small issuances, but nothing significant really. And even for those, the disclosure obligations are sufficiently onerous that given the small dollar amount, there's not a lot of uptake, especially on the crypto side, which leads us to exactly what you were talking about with Reg A, or as people call it, Reg A plus, because of an extension a few years back that raised the cap. And in fact, that cap is going to be raised again in a few months unless there's a change with the new administration. So right now you can raise up to 50 million. It may soon be up to 75 million. There are disclosures required in terms of audited financials and such. And significantly, unlike with Regulation D, you have to get these things approved in advance by the SEC. And that's where the tricky part comes, because it's straightforward to follow all the rules and fill out the form to get your Reg A issuance of a security token. And then you send the thing into the SEC, and people there are just reluctant to approve these. There have been Reg A issuances with non-tokens, like that is securities, ownership of which is tracked on a traditional ledger. But for distributed ledger technologies, the combination of that with the likewise novel Reg A Plus has been almost a bridge too far. I would love to see more of them, and we are working on some. We're trying to get those out there, but the SEC is slow to approve those. I would love to see many more, and I think we will see them. But you're right; it's not been a big share of the market thus far.
Okay, absolutely, absolutely. I think we tried to make this. Thanks a lot for the great wrap up for the US, and I think that we really tried to make this panel a practical one for those who would like to conduct a security token offering or are already maybe involved. You're absolutely right. We have seen, I would say, not much. I mean, around maybe 10 or 15. In the US, maybe there are more. We have seen over 10, 15 in Switzerland. And we have seen also, less than 10 actually, also in Liechtenstein, and we've been involved in some of them. And the question is actually, why? What's holding up the security token market? The thing that you have already mentioned, I think, is the secondary market. And we move on with the next topic on, let's say, practical criteria for choosing a country for conducting an STO and some practical issues that you see in conducting an STO. I'll mention the first one. The issuance is not that bad. So you can do it for European investors in Europe, for US investors in the US, for Asian investors. You have really check all the legislation of all the countries where you're going to conduct the public offering. And security token is most likely a financial instrument there. But then where are you going to trade it? Where the investors can make an exit? That is an issue, I guess. The secondary market, and the second issue is Natalya mentioned the custody depository, because in most of the countries you need some sort of a central depository, or you need to use banks to do so. And in some of the countries, the banks are not really part of the crypto blockchain infrastructure. They just don't want to play together. These, in my opinion, are some of the most important issues when you conduct a security token offering. What are, in your opinion, the let's say the practical issues for conducting an STO?
As in to choose a jurisdiction, you're saying?
Yeah, within your jurisdiction. I mean, regulation is just one part of the story. What are all the practical issues that you see that projects face?
Well, okay, so the adoption of crypto is still relatively small in the US compared to some other jurisdictions. Maybe 5% of people in the US hold Bitcoin, well under that hold Ether. There are just a lot of people who haven't touched this. That said, it's an echo chamber. The people who are in crypto talk about it all the time, so they think it's everywhere. So you're limiting it. So while the US is obviously a huge economy, and you gain certain you gain a perception that your company is for real when you list in the US, because if you can make it there, you can make it anywhere, because the rules here are so onerous. They're picky about disclosures and such. So there are benefits to listing in the US, but people can, that is the number of dollars that go into investments in crypto and the number of people investing in it are perhaps lower here than in some other jurisdictions. And in the US, you mentioned regulations. I don't want to limit myself only to that, but part of the complexity in the US is that we have this federal system. And so there's this crazy quilt of different regulations in the various states. You can, with some of the exemptions for securities issuance, deal with just the federal side and hope, and then that preempts the state laws. But for some activities, not just on the issuance side, but on the trading side and whatever else, in terms of just shipping, transferring virtual currencies, transferring various digital assets, you run into state regulation at this side, which can complicate things. And I know a lot of people, a lot of companies that intentionally avoid U.S. jurisdiction because just the impression is that it's easier to be sued there. Things can go wrong. Regulators are looking to make an example of people. So even if the laws are pretty clear cut, which I think they are now, where we have much less uncertainty in the U.S. than we did before, and there's a solid rule of law, traditionally low political risk and such, or great changes. The fact that there are perhaps crackdowns coming on DeFi down the road, just like there was on security issuances and such earlier, some people say, maybe let me just not trade on that. You mentioned secondary markets. Think about how many exchanges located outside the U.S., when you read their terms of service, say, we accept anyone. Except, of course, the U.S. No U.S. traders, please. There are lots of exchanges that steer clear of this because the way regulators say, if you are operating an exchange that invites U.S. persons, you must do A, B, C, D, E. And they just don't want to go there, which means that U.S. persons have limited ability to trade out of these things, which in turn decreases their willingness to buy something that they could find illiquid once they hold it.
Absolutely, absolutely. Thank you for wrapping up all these practical issues in the US. Steve, what do you know about practical side of the STO in Malta? How does it work there? How many security token offerings have you seen so far?
Yeah, so this is like a double-edged sword. It's two sides of a coin here. Pardon the pun. It's not a crypto coin. It's the physical coin with two sides. Because up until now in Malta, we've seen only one security token offering, which happened just a few weeks ago, maybe a couple of months ago. And one can look at this and conclude, oh, it's not working. Or the other conclusion is it's working too well because the bar has been set so high that not many are able to overcome that hurdle. And in fact, I think it's this second element, which also explains why the Blockchain Island project, in a way, sort of capsized midway. Malta, as you know, has several reputational problems as a jurisdiction besides the cryptocurrencies and blockchain technologies. So one side effect of this situation was that the regulator, not the legislator, the regulator made it extremely hard to pass all the tests, to the point that those companies that were attracted by the early announcements that this sector was going to be regulated in Malta, most of them actually went to other shores. So it backfired. But having said that, if you look at the laws and the regulations, they could still be considered as a role model, so to say, that could inspire, especially Europe now that it's going in this direction, to copy them. However, another point is that the legislation here has also, in view of the difficulties of companies to do their launches here, has created this new class of professional lawyers, which is known as the VFA agents, the virtual financial assets agents, which they have to pass scrutiny and exams, and the objective is to assist the companies that want to list in navigating through all these hurdles. So that is also one aspect that I think needs to be highlighted. It's not just the regulation as such, but it's also creating the new legal professionals that can master this new field. The risk otherwise is that maybe extremely expert and renowned lawyers start dealing with this field with all the knowledge they have in traditional securities legislation, but they miss like the subtler details of the connections to the crypto world. And that's where Malta has acted with the Virtual Financial Assets Act and the institution of the Virtual Financial Assets Agent.
Mm-hmm. Okay, I see. That is a really good wrap up of the practice to STOs in Malta. Natalya, would you like to add something to the practice of STOs?
So, as I have told before, we have now the relevant legislation here in Ukraine still, but we have lots of people, lots of clients who are very interested in STO. And the main question they are asking, their criteria for choosing right jurisdiction. So I hope that today's speech would be very interesting for them, because one of the most important messages how to choose jurisdictions is a difficult thing that depends on the specific case, the specific project, and there are many aspects. And clients are asking, what type of security could I choose, and what would be suitable for my business model? So are there any problems, or will I meet some problems with double taxation or the simple taxation? How would it be? Security or utility, and is it very important from where my investors come from? So, and accordingly to these questions, I would like to try to help them. Why I have asked previously the question which jurisdiction would be suitable, because one of those questions also is how could I deal with some custodian, because I do not know. Do I need to report when I sell my shares like securities in the moment of the purchase, or could I do it at the end of the year? So, and all these questions are very, very important for people who wanna deal with STO. As we do not have such legislation in Ukraine, we were trying to examine US legislation as well, like state of Wyoming, Liechtenstein legislation as well, and some other. So, and we still do not have answers for that question. So that's why I would really appreciate if we could clarify them.
Definitely, I would try to put it together maybe with the question on legal costs that was also on our agenda. So if I try to wrap it up, the most practical issues are secondary market and custody. And I think that in some countries they are covered by the national legislation, in some or guidelines by the regulators, in some they are not. And I think that in regard to the EU, MiCA will cover most of the issues, because they're introducing this pilot regime for the DLT trading facilities. That's really exciting, and I think I suppose and I hope that this will be the issue for secondary markets, the solution for the secondary markets. Regarding the criteria for choosing a jurisdiction, legal cost is actually one of the criteria, because some of the countries, let's say I've heard recently that there've been one security token offering in Lithuania. Have been also, or they're doing it right now in Latvia, using some of the national exemptions. But if you do it, you really should look at your target investors. I mean, if your target investors are in US, do it there. If your target investors are in Europe, do it in Liechtenstein, Malta, Latvia, Lithuania, whatever, using both MiFID and prospectus directive, either within the exemptions or do the full prospectus. In regard to Asia, just see how it is regulated there. Always start with your. I think it works for a lot of businesses like that. Always start with your consumer. And with financial instruments, especially, always start with the regulations in a target country. That is, I think, for a lawyer this is quite obvious, but for a lot of projects I discovered it's not. They're like, okay, let's go to Liechtenstein, Malta, Switzerland. They seem to be crypto friendly. Let's do it there. No, it doesn't work this way. Or I think one of the questions that have been asked a lot, can we do security token offering in one country and sell it over the world?
Yeah, exactly.
Most likely no. Most likely no. Or if you would like to target retail investors all over the world, then definitely no. Talking about the legal costs, I think that there are countries, okay, Lithuania, Latvia, Malta, something I think comparable to Liechtenstein. Switzerland is one of the most expensive countries in general, and in regard to security token offerings especially. What kind of models I have seen till now working with lawyers is that even with larger law firms, you can still agree on, let's say, some sort of fixed fee plus percentage from STO or equity, or yeah, something like that. That they also participate in your project, and then you, by way of doing so, you can lower the legal costs. Yeah, that is actually has been a solution, and also I think for the future, for now, because it is so new, there've been only few STOs in US, Europe, in other also some security token offerings in Asia, and that's why the lawyers have to do everything, let's say, write the new prospectuses with new risk factors in regard to security tokens, and that's why it costs so much. But I think once there will be a lot of tokenization, asset tokenization platforms, or platforms offering crowdfunding, security token offering opportunities to others, to other projects, all the processes will be streamlined and the cost will go down like that. I mean, right now in Switzerland or Liechtenstein, you can have from, let's say, 30, 40K up to 150 to 100K with a big four law firms. I think it will be like 10K or 20K in 5 years, I guess. I could even bet on that, but I won't.
Yeah, 20K.
So what would you think?
Yeah, so it depends on it depends on the difficulty of the project. So mostly we've checked that all this time to prepare, well, investment agreement, all memorandums to incorporate the jurisdiction, so and so on and so forth. It will cost near, it will start from 20K, like something like that. But I've heard that you told that if you want to sell worldwide, you should choose a few jurisdictions, not only one.
Well, if you conduct a public offering to retail investors, most likely yes. Then you can choose different exemptions.
Yeah.
You can do private placements. Then it's okay. You can do it from one country. Let's say you can issue a security token in Switzerland and offer it within private placement in the US, but still at least consult the lawyers there even if you do the private placement.
Yeah, so it's also one of the things why clients are and people are a little bit afraid of doing that. So we have just a few projects worldwide of STO because of unknown field like Wild West, which jurisdiction they choose, the costs, and but from the other side, if you're gonna be first, you can be Apple in STO.
Well, maybe we'll see. I think the market is getting more regulated, and in 3-5 years, it will be already divided between the major players. But we'll see. Zach,
Yeah.
Steve, what would you like to add on the practical issues of STO, on costs and criteria for choosing a jurisdiction?
Well, I think your advice at the beginning that you should start with where you think you will find your investors, and then like reason backwards for that. So if you're interested in the US investor market, because it is obviously the largest one, well, think about getting regulated there rather than in Malta. But if you want to go to Europe, then any European country is good, because as this evolves with MiCA, there will be a uniform legislation across all of Europe. In terms of cost, I think that when uniform legislation comes about in Europe, even the differences in prices will go down. The cost of compliance, so to say, here in Malta is probably one order of magnitude larger than the amounts that you mentioned, Yanina. So that explains why many just went away. It was far too expensive to get regulated here. So competition between jurisdictions, I think, will be an element of important element, a factor. Not so much in terms of interpretation of what these instruments are, because at the end of the day, there will be a convergence. Standards will be set even at the basic technology level. We have like the ISO standards and several others developing. So from that, like architectural standard interpretation of what the technology is, you build up, and eventually you will get to the legislative interpretation, which will be compatible across jurisdictions. But even so, the competition between jurisdictions, I think, will be a key factor. And for instance, the cost of compliance will be a decisive factor. And there I go back to, this was the connection I wanted to make with the notion of law is code. Those jurisdictions that will be able to first enact the implementation of law in the computer code underlying the exchanges, the instruments, the smart contracts, and everything, will definitely have a huge advantage, because basically, like all applications of automation, the cost will plunge, and therefore it will be a huge attraction factor. And this is a bit what I'm doing. You might know I'm also advising the Republic of the Marshall Islands on the adoption of the SOV, the SOV, the crypto legal tender currency, where, for instance, monetary policy is being encoded on chain rather than regulated by a central bank. So that is like one example of how this could be done. It is for the monetary policy part, but of course the same notion could be transposed into the regulation of securities, and therefore those jurisdictions that will understand this opportunity and implement it will have a huge advantage.
Thank you, Steve. That's been a really great note also regarding the future of the regulation. I see that both Switzerland and Liechtenstein, they're working, and I see some examples of the projects which already use, let's say, transform normal, especially financial market contracts to smart contracts. But I haven't seen examples till now when the central policy is already encoded. That sounds great.
That's the big one. That's the big one.
Absolutely, that's so great. Zach, what would you like to add?
Just briefly, first of all, I agree with you entirely that issuers, that is companies looking to raise money, should look to where their investors live, and then that's the natural place for them to raise money. And I want to clarify something I said earlier when I talked about the size of the US market. While adoption of crypto might be low here, just the size of the market is still so large. There's plenty of opportunity to raise money in the US. I don't want to scare people off of raising money here. Some investors steer clear of security tokens within the US because of the limited availability of secondary markets. But investing in utility tokens and other kinds of things, people are still interested in. And to the extent that the secondary market grows, I think we'll see a growth in the investor base for security tokens as well. And when you talk about standardized language, I think we're already getting there. So we try to, for Regulation D issuances for security tokens, where you're raising money from accredited investors, we'll put one of those together for like 10 or 20,000 US dollars. And for Reg A1, we're more in like the $50,000 to $75,000 range. So, that's more or less dollar-wise what we're talking about. And we see people reaching out to us about these all the time. Some of them come to us asking us to help design their tokens so they fall within a particular regulatory regime, or help to design them to meet a particular economic need. But there's plenty of activity here. Even if the numbers are still small, they're growing. And if there's one thing we've learned from 2020 is we've seen how exponential growth works. And I think we're going to continue to see that in the STO market.
Okay, great. I think there is almost time for the next panel. We have a very interesting question, but it wasn't initially on our agenda, so I believe we would not be able to really cover it regarding the tax implications. I think it is just to mention.
I think we still have 5 minutes of the discussion before the next speaker joins in. So
okay, I see. Okay, I see. Then we could maybe jump to this question about the tax implications, because it is really important. I think that regarding the individual investors, they solve it within the taxation of, let's say, physical persons in the countries, how they tax securities there. And then regarding to the amount of money that you raise, it is also solved within the national legislation of the country. Some countries have stamp duties. Some some can tax the money within the STO. You can have profit tax. Within Switzerland and Liechtenstein, the practical solution is that you put it aside as reserves, but then you still need to get a ruling from the local tax authorities that they agree with that, and you can pay taxes, let's say, less or later, but still you need a ruling. You still need to discuss it with tax authorities. What would you like to add to the tax issues?
Yeah, Yanina, I would like to tell that tax implications are very, very important. But when you build your scheme, you should also keep an eye on some CRS rules and FATCA rules that will also be here, and you should keep an eye on some possibility to deal with banks, because banks are very, very careful while taking on board the clients, especially individuals, because due to some CRS rules, they should investigate, they should make KYC of your client, they should be sure where money comes from, and when you're gonna pay them some dividends or some other money, you should also be very clear with the local taxation of these neutral persons.
That is really important that you mentioned the common reporting standard and the automatic information exchange in tax issues. That is, yeah. Zach, Steve, would you like to add something?
Well, I don't want to double down too much on the tax side because a lot has been said already, and I know we have limited time. But would you mind? I see a second question came in also. It seems to have been directed towards something I said earlier. May I just address that, please? It seems there was a question. Someone said that based on something I said, they got the impression that just about all utility tokens would be securities, and the questioner was asking how someone could issue tokens in a way that they would not be securities. And so since I perhaps caused that problem, I was hoping I could address that. There are definitely ways you can issue tokens that are not securities. First of all, there are stable coins. I realize that won't help you to necessarily raise money, but as far as just a business model, you can do things with these. So there are tokens that you can issue, trivially stable coins, that you could avoid having be deemed securities. Also, if when you issue a token, you quickly decentralize it, so that is you just let the world, let it be out there and say, this will be a medium of exchange for what we're going to do. We're not going to control it. We will not administer it. It is just out there, much like with Bitcoin and such. This is another way to bypass security status. But in particular with relation to utility tokens, the key point there is if the ecosystem is already up and running. Under the US laws, if you have already built a system, and now you're doing sort of a round B, round C, that's a follow-on series of raises because you already built what you have, or at least to some extent. So what you have, people can use your token on day one. Then you can say, great, we will sell this, like I forget whether it was Natalya or Steve was talking about tickets to use this in the future. But even right now, people could buy this and immediately use it. If the system is already up and running, so that when people buy these tokens, they can, if they want, go and just put their coin in the vending machine and get the services out, then you're much more likely to have your token be deemed a utility token, not a security. If you are rather issuing a token, and while you say it gives access to a system, it is that you're issuing it to raise money to build that system, which is not yet in place, that's when these things that look like utility tokens eventually get deemed securities right now when the system just isn't live yet.
Great. Really great comment. But I just see that it gets more and more difficult to issue utility tokens, especially in the US, but also in Europe, which still could be considered utility tokens by the regulators. Yeah. Okay. Steve, would you like to add something to the taxation issues or to the panel in general? Because I guess it's time to sum it up.
Yeah, well, I started saying that I'm not a lawyer, and I probably should end saying that I'm not a tax advisor either. So tax issues are clearly a very important element of this whole industry. But I think it goes back to the basics. If the classification is clear, then also the taxation is clear. Problem is that the classification is not clear yet, and it seems that it might even get more convoluted. I'm thinking, just to give you an example of this field of identity of things, where the clear identity of some object, some physical element, some physical asset can be put on a blockchain and hence can be tokenized and hence can be put on a trading platform. Well, then you are clearly getting in another very gray area of, is it a security? Is it a commodity? Is it something else? There are examples of, for instance, pieces of art, precious piece of art that have been tokenized, and you have schemes of fractional ownership and so on and so forth. So what is it that I'm selling there? Is it the ownership of the art? Is it the right to the ownership? And all these things have different tax implications. So I think we've just seen the start of the need to clarify how all these things are interpreted, and then how the various regulations and taxation rules are applied. At the end, I go back to my message. The jurisdictions that will be able to codify these things on the platforms will take out so much friction out of the system that they will have a winning proposition. It's what I call, and it's what is also known as the attraction regulations. Build regulations that are attractive for both the investors and consumers of your products and services.
Absolutely. Well, guys, I think that we have to wrap it up. It was really great to have all of you on this panel on this Saturday morning, at least in the European time zone. We had a great discussion, I believe, with some practical inputs regarding how conduct an STO, how to choose a jurisdiction, what are the regulations in the most important market. We covered mainly US and EU. Well, looking forward to the implementation of the MiCA to the secondary market for STOs to be implemented in Europe, and we'll see how it's going to develop in a couple of years. Have a great weekend.
My friends, thank you for the panel. The discussion was fantastic, and I'm sure we all learned so much. I think that you devoted your time to education and spreading knowledge, and this cross-national collaboration of lawyers, which is something we definitely need to make global issuances easier. So I thank you all again. Thank you, Steve, for sharing the non-lawyer perspective as well. We definitely need all of this as well. And have a great weekend. Also see our next speeches and workshops as well. They are going to be great. So thank you, everybody.
Thank you.
Thank you. Bye.
Thank you.
Bye.
Yeah.